Everyone treats summer like it owes you happiness. Long days, pool parties, your best life on a loop. So what does it mean when you feel worse? The summer blues are real. It's why summer is one of the busiest stretches of the year for people starting therapy. Therapy is not only for when you're in crisis. Grow therapy is for all the moments when you decide you want more. More support, more clarity, more tools. Mental health isn't a destination you reach. It's something you build, and Grow makes that easier. Grow connects you with thousands of high-quality licensed therapists across the U.S., offering both virtual and in-person sessions, nights and weekends. You can search by what matters, like insurance, specialty, identity, or availability, and get started in as little as 2 days. There are no subscriptions, no long-term commitments. You just pay per session. Grow helps you find therapy on your time. The therapist you want takes your insurance on Grow. Grow accepts over 125 insurance plans. Sessions average $21 with insurance, and some pay as little as $0 depending on their plan. Visit growtherapy.com/booknow today to get started. That's growtherapy.com/booknow. growtherapy.com/booknow. Availability and coverage vary by state and insurance plan.
This episode is brought to you by Progressive Insurance. Do you ever find yourself playing the budgeting game? Well, with the Name Your Price tool from Progressive, you can find options that fit your budget and potentially lower your bills. Try it at Progressive.com. Progressive Casualty Insurance Company and Affiliates. Price and coverage match limited by state law. Not available in all states.
Hello, this is Mark from the Swamp School, and I want to welcome you to our August 2021 Wednesday podcast. We try to do these about once a month, and looking back a little bit on what happened the previous month or so. And July 2021 was pretty busy. There were a lot of things came out related to wetlands. First of these is related to the president's attempt to do a program called 30 by 30. And what this is a program that would put 30% of the U.S. land mass into some sort of conservation easement by the year 2030. And that is an interesting goal. The report, which we have posted up on our podcast page, so if you want to pull it down, we've put it up there, claims that there's about 11% of the U.S. land masses in conservation easement, and this would push it up to about 30, so about more than double what is currently in conservation easements. I'm a little suspicious of the numbers that are basically being proposed, because I suspect that number might be higher than 11%, given that a lot of the conservation easements aren't really inventoried in any way that you could quickly put this together. So I'm really not sure how we'd gotten the number in the first place. We may be at 30% already, so we'll see. But anyway, it is tied into it's buried in there in the infrastructure spending bill, and this is something just to kind of pay attention to. So take a look at the report and let us know what you think. We've also had an interesting legal action take place in South Carolina. The district court down there had basically thrown out the challenge to the Navigable Water Protection Rule, essentially as a program. And essentially what happened was the Navigable Water Protection Rule was being challenged and, I guess, defaulting back to the Obama-era 2015 Clean Water Rule. However, there's actually a 2019 recodification of the 1986 rule that actually, I think, sequentially would have been where they would have ended up. But nevertheless, getting into legal stuff, it basically went nowhere because the judge threw it out. Largely, this is kind of paralleling the challenge that took place a while back in Colorado, where essentially the judge had declared that essentially there was no aggrieved party. The Navigable Water Protection Rule essentially reduces the amount of federal involvement in waters of the United States determinations, or at least what's considered a federal water states, leaving it to the states to pick up the slack on things that are smaller or less connected, I guess, if you will, to larger water bodies. So the judge basically threw that one out in Colorado. This judge in South Carolina didn't really go to great detail as to why it was basically thrown out, but it was just simply felt, I guess, following precedent. So to that end, that has kind of derailed the last really major challenge to the Trump era rules. It's possible that there may be some other cases floating around out there, because there are other cases, but that may also challenge it. But this one was a pretty big one and a pretty big loss for the folks that were fighting against it. So to that end, just giving a heads up there. Now, Congress has not been without note on this. There have been two sets of laws that are basically being proposed. One basically has a House and Senate bill version, which essentially is to recodify the Naval Waters Protection Rule. And not entirely sure what this really accomplishes, but I think really what it would amount to is if one of these cases were to go forward, we'd have an interesting problem where Congress has recodified its intent that the Naval Water Protection Rule is what it had intended to regulate under the Clean Water Act. I think that's really the angle there. So it would defeat a court challenge, or at least bring it before the Supreme Court again. So that would be an interesting development there. But basically, there's a House version and a Senate version. They're essentially very similar bills. They have slightly different titles, but similar bills. And basically, those are being brought up. They came up about a week or so ago. So they're being kicked around. I doubt they would go very far because it obviously would require the president's signature, which there's no way he's going to do that. So these would really go nowhere, and there's no way that they would be able to get the votes to override the veto. So to that end, these really won't go anywhere. But it at least lets you know that they're where the direction is, where they're headed. And the organizations that are very, very heavily supporting it are the agricultural industry, specifically, the beef and cattle industry, the dairy farming, all basically the large animal type programs are very, very much behind these types of bills. So that's what's going on there. To dovetail into that, there is actually a new version of a bill that has been circulated around for years. It's kind of come and gone, but this one just came up, and it's interesting because it was basically drafted, authored by Senators Cruz, Rubio, and Paul, which is an interesting group to get together on this. And essentially, this particular bill, which is only a Senate version right now, does a number of things that kind of clarifies some roles in government. And there's three major points that came out of this. It's a rather short bill, but it's an interesting one. In that one of the points, of course, is that it's going to designate the states there's actually 4 points, so it's actually kind of fun. The states that are basically responsible for these waters, that essentially the federal government is not going to impede the states' rights to continue to regulate above and beyond what the federal government regulates, which is an interesting point because I know in North Carolina we have a provisional or temporary rule that is concerned with the fact that if the federal government doesn't regulate it, that the states can't regulate it. And they're really looking at, they're trying to basically create a rule that says that. Well, that's not actually true. The states can regulate it. And this bill underscores that point. There's nothing in the Trump era rules that would preclude the states from basically claiming jurisdiction over another water, just they have to pass the laws. So that's definitely a political hot potato, but they have to pass the laws. The second thing that came out of this is that the significant nexus test is basically not allowed. They're not going to accept the significant test. The significant nexus test that came out of the Kennedy decision during the Rapanos era, 2006 rules, 2007 rules, when those came out, was based on the Kennedy's opinion of that case would not be used for any sort of jurisdictional determination. So they specifically call that one out. So that's an interesting one. The third one and the fourth one are the real interesting ones. The third issue on this is that it has to do with right of entry, and specifically this would be related to violations cases where if you're a particular property owner and you are doing something on a wetland that maybe you shouldn't be doing, well, if the Corps happens to be driving by or the EPA happens to be driving by or USDA happens to be driving by or anybody else basically from the federal government happens to be driving by and they see you filling in a wetland, that they have what would be amounted to in police and probable cause, and they come on and they basically cite you for violating the Clean Water Act. And they get into civil and criminal violations potentially. Well, this particular bill requires that the property owner have written authorization. The agencies have written authorization to enter the property, basically a warrant. They have to get a warrant from a judge to come onto the property. So just driving by may give them probable cause, but that's not enough to enter the property. They have to have either written permission from the property owner or they have to go get a warrant. And that's the only way they're going to be able to do it. So the driving by is not enough to issue a violation. So that basically gets into some of the due process cases that have come up over the years about, how did the agencies become aware of this violation? And, driving by and seeing it is not enough to come on in it, into the property, because presumably you can't tell that something's a wetland from the road. You have to go in, you have to do the 3 criteria, and you have to evaluate it. And that would only be possible if you were actually on the property. So even though there's cattails growing and you're filling in a wetland and it looks and there's water and you can see the water, you can't see the soils. I don't know, maybe you can see the soils. I don't know, but you get into an interesting issue there. So it's an interesting point of law. So it has most to do with due process. So that one would certainly complicate things. The last point on this one has to do with the takings issue. And I have a very good friend of mine who I used to work with back when I was doing consulting up in New Jersey, who back in the 80s was yelling about this. So this is a shout out to my dear friend Kirk. So if you're listening, Kirk, this is for you, which has to be a takings without compensation. The idea is that when the federal government claims that a piece of wetland or a piece of land is a waters of the United States, that means that you are not able to do all the things you'd like to do to it, and therefore you have a perceived taking by the federal government. So therefore, you're entitled to compensation. So that's never gone anywhere. Well, this bill actually underscores that point and simply says that there is a perceived value of the loss of use. So we have an appraiser now has to go out and essentially establish the loss of use, and then the federal government will pay the landowner twice the value of that perceived loss. So there would be some sort of appraisal and then a monetary compensation for the land. So that will be an interesting development. So there's no House version of this yet. There may be, who knows, but again, the same issue. I don't see the president ever signing this, and it's certainly not a thing that could override a veto, but it is also a particular bill that has been floating around for years, so just looking for the right time to reissue it. So it's interesting. But what I did find interesting is that the authors, Cruz, Rubio, and Paul are, pretty heavy hitters for the Senate on this, and for them to be the authors of this is kind of interesting. So I'm not sure where that's going, and there's just some reading political tea leaves there, but it's interesting. So to that end, that's kind of the big news of the month here. Definitely appreciate you listening in on this. We've got a lot of fun stuff coming up this fall, and definitely check out. We're back doing our classes. We've been expanding our facility in North Carolina, and we'd love to see you come down to one of our classes. We got a class in Pittsburgh coming up the end of August, and we've got a few road trips here and there. We're expanding our stream restoration program that has been a terrific success both online, and we'll be offering an in-person version very soon. And we have a number of other online workshops, webinars, so forth going on. So love to see you in any of those. Definitely drop us a line. Let us know what you think of any of these topics. You'll feel free to comment in the posts below on the blog page, and just let us know what you're thinking. So with that, I wish you much success in what your endeavors, and we hope to see you in the swamps very soon, and definitely stay in touch. So take care and have a great month. Thanks.
You know what's wild? Most people are still overpaying for car insurance just because it's a pain to switch. That's why there's Jerry. Jerry's the only app that compares rates from over 50 insurers in minutes and helps you switch fast with no spam calls or hidden fees. Drivers who save with Jerry could save over $1,300 a year. Before you renew your car insurance policy, do yourself a favor. Download the Jerry app or head to jerry.ai/Libsyn. That's JERRY.ai/LIBSYN.